Now, in the Zondo Commission, an extreme amount of evidence was given, indicating beyond any shadow of doubt that this is in fact what South Africa has become. Now, not much has happened as a result of the Zondo Commission. Why? Because the state institutions that have to act against corruption, crime and so on are simply so broken down as a result of our dilapidated government, African National Congress, that no proper action was taken. In that case, Malema was cross-examined by the advocate, by Mark Oppenheimer, and he was specifically asked, Mr. Malema, are you prepared to make a commitment that you would never call for the large-scale killing of white people? And he explicitly said, no, I am not. The integrity of the South African courts, and I know that's harsh words to utter, but they are well-founded, and therefore I, as a constitutional jurist, can bluntly say so. They simply lack the impartiality, and they simply lack also the judicial integrity to discharge their functions when it came to questions of that kind.
Professor Koos Malan, thank you for joining us and welcome back to this channel and to this platform.
Thank you very much, Ernst. Thank you very much for the kind invitation. It is indeed pleasant to be here.
Yeah. So just for our viewers so they know, we had a discussion before recording this in terms of what we want to discuss and what we want to cover. And we actually came up with the idea that there are, broadly speaking, 3 topics that we would like to discuss. So we are going to record them all at once as one long conversation, which will be longer than our podcasts usually are. And then we're going to break them up and probably publish them separately. And so just a quick overview for the viewers who are interested, if they're only watching this, the first episode now, we want to talk about what's happening with the courts and, in a certain sense, the deterioration of the justice system, or the checks and balances in South Africa as they are known, what's happening with the courts and the legal system. And then we want to talk about we want to take a step back and look at the broader picture of what is happening in South Africa and the extent to which there is a deterioration happening. Or you could even say the extent to which the constitution is already changing in South Africa, regardless of the text. And then thirdly, we want to talk about the future and why certain changes, even though they might seem alarming or concerning at first, are not necessarily bad, and that this also provides some opportunities. Is this more or less how you understand it as well?
Yes, absolutely so.
Great. So I think we need to start with, we recently had this Kiel the Boer judgment that was very concerning, and a lot of people took note about this. And you are the author of the book, There Is No Supreme Constitution, in which you have expressed, I think it was published in 2019, if memory serves me right.
That's right.
In that book, you have expressed some concerns about the certain recent developments and the fact that people do not necessarily see what is happening in terms of the legal system. But even though you don't present it as such, you also make what you could describe as some predictions, because you talk about the direction things are headed and could be headed in the future. And a lot of that is what we are seeing in South Africa. So maybe we should start then with the Kiel the Boer case. Do you have some comments on this? The fact that the Constitutional Court has now said that it's not hate speech. They actually said they're not even going to hear the matter.
Yeah, Ernst, it's very important topics to discuss. The reason why it is so crucially important to focus upon the judicial system and what we could regard to a considerable extent as the malfunctioning of the judicial system is that the South African courts, back when the Constitution was adopted, the interim Constitution was adopted in 1994, and when the present Constitution entered into force in 1997, the South African judicial system was presented as one of the best examples what a judicial system could look like, as being a system in which checks and balances, in which the courts play a crucial role, as a system in which those institutions that safeguard those checks and balances were really in place. What we have seen in the meantime is precisely the opposite. In the book that you've referred to, the 2019 book, I discussed that in fact in detail. And what we have seen since that time is that much of the analysis that was done there has actually been corroborated, has actually been confirmed by what has been happening in the interim, since in the period after 2019.
Yes.
The essence is this, and I think especially for our viewers outside the Republic of South Africa, because many South Africans are fairly quite used to what we are grappling with in South Africa. But a viewer in the United States or in Britain or somewhere in Western Europe might find it quite strange, and therefore it calls for some explanation. The fact of the matter is simply this. In accordance with the general doctrine of constitutional law, it is said that governmental power is separated into three legs. Namely, that's common knowledge. In the first instance, the legislature, secondly, the executive, and thirdly, the judicial function, which is vested in the courts.
Yes.
That is regarded as the core instruments that must be in place in order for a proper system of checks and balances to be in place. That is in fact incorrect. The fundamental reason why that is incorrect are basically, for the purposes of this discussion, twofold. And that is that far more important as a check and balance are institutions outside the formal state structure, especially the media, institutions of civil society, and private business, and that we have seen in South Africa. These three institutions, and one can add to that, outside the state structure, are actually of much more import and much more consequential when it comes to securing a proper constitutional dispensation. Yes. Now, that's the first point. The second point is this. The basic separation of powers boils down in the final analysis to only two things. And this is that there is a separation as far as functions are concerned. The executive cannot do the same as the courts. The courts give judgment, and they are stick to giving judgments. That's what they can do. But the executive and the legislature cannot do that. So it's firstly a question of functions. And secondly, it's a question of staff, personnel. The people filling positions in the legislature as legislators cannot be members of the court. They cannot be justices. They cannot be judges. But separation of powers does not go beyond that. And the important thing is to realize, and that is a point really that one must actually stress, is that even though you have that separation of staff and of functions, you don't have a separation as far as ideological assumptions and ideological objectives are concerned. Specifically in South Africa, all three legs of state power, the ANC, which dominates or has dominated to a large extent still, which is still to a large extent dominating the executive, the legislature, also dominating the executive as well as the courts through a variety of instruments. For example, the Judicial Service Commission, which is populated by mainly people coming from the executive and being members or supporters of the African National Congress. As a result of that, all three are actually anchored actually subscribing to the same ideological assumptions, namely what one can call transformationism. And what we've seen in the past years, and that can also be demonstrated through a large number of judgments, is that whenever a matter comes before the highest courts, especially the Supreme Court of Appeal and the highest court in South Africa, the apex court, namely the Constitutional Court, if you have a situation, if you have a case in which the bone of contention somehow touches on the fundamental ideological assumptions of transformationism, you can predict almost for sure that somehow, even though you might think that your case against that is very strong, the court will eventually subscribe to the ideological assumptions of the African National Congress, that is, of the dominant section in the legislature and in the executive. Now, what is that? That is the ideology of transformationism. And I think one must just say one or two things about that so that people can really understand that.
Yeah,
please go ahead. In the first place, we must realize that the African National Congress is a radical leftist political actor. Lately, it has actually shown more of its radicalism. It's radical leftist. Hence, it strongly subscribes to socialism, and it strongly subscribes to centralization so as to accumulate as much as possible power, authority, and as far as socialism is concerned, also property. Giving it all the necessary tools in order to push through its policies. And then lastly, it is also strongly committed to the idea of cultural homogenization. In other words, there must be one single statist culture, and as far as possible, the so-called national question, which is how to deal with cultural minorities such as the Afrikaners or whatever other grouping in South Africa, there must be no recognition for them. As far as possible, no recognition for such communities. To the extent that there was such recognition in the past 30 years, since the Constitution entered into force back in 1994, it is only as a result of the fact that the minorities who still exercise those cultural their own culture, enjoy their own culture, perform their own culture, is only because they were strong. And only because of the fact that the ANC did not regard themselves as strong enough to actually go against that. But the moment they think in terms of their own assessment of their power and also the counterpower of the opponent, they actually push forward. We have seen that with legislation dealing with education, the so-called Bela Act. So that, in a nutshell, is what transformation is. Leftist, centralized, and homogenization. That is what it's aimed at. And just lastly, as far as that is concerned, you also see that there's a consistency between the internal policies that I've just mentioned and the external policies, to the extent that they are pro-Iran, the African National Congress, to the extent that they are pro-Hamas, to the extent that they are pro-Cuba, pro-Venezuela. It's also associating themselves with leftist powers elsewhere in the world. So there's a consistency between that. No break at all. That is actually exercising their character both internally as well as externally.
So I think this is a very important thing for people to understand, that again, theoretically, if you look at the Constitution of South Africa, you get the impression that these three things are separated. You have the president over here, and you have the courts over here, and you have the legislator over there, and they function independently from one another. When what you are saying is that there's actually something like there's a cohesion between them. It's part of, I think your words in the book is, it's one ruling elite.
That's right.
With different functions, and there are many examples, and perhaps you touched on some of them. But there have been actually quite a lot of court cases over the last decade, but you could say few decades, that came as a big shock to a lot of people. And I think it comes as a shock if you do not understand this point, this exact point that you have just made. If you look at the text of the Constitution and you interpret this through your own lens, which typically is a liberal democratic lens, and then you expect the ruling elite to comply with that. And so you mentioned the culture. It sounds almost extreme the way you framed it, but that is what the Constitutional Court said in the case about the Pretoria street names, where I remember that case was it was AfriForum that brought the case, and it was about some problems with the process that was followed to change the names, the street names. And the court, even though I think the court conceded that the process was flawed, that was supposed to be the matter before the court. It then it spoke about substance over form, and it even went as far as saying that the Afrikaner people have a history that is soaked in blood, and therefore when we talk about rights of cultural minorities, this should not apply to them. But that's just one example. There are many others. Maybe you can shed some light on a few of these.
Thank you. I think that's an important question. Just to add on to what you've said, in that case, in the Pretoria street name case, the Chief Justice at the time, Mogoeng, in that judgment went so far as to say that there's a problem in the sense that the Afrikaners seemingly do not want to associate themselves with the idea of transformationism. Well, I call it transformationism because the ism actually indicates that you're dealing here with an ideology.
Yes.
They refer to it as transformation, as if it's some neutral process, which is actually a cover-up.
Yes.
It's a misrepresentation. But so in a nutshell, they say, well, the Afrikaners refused to associate with transformationism. So that was clearly the courts blatantly associating themselves, positing themselves as part of the governing elite, and then serving as the judicial excuse, the judicial justification for transformationism.
Yes.
There are various other cases. In the case of Agri-SA, that's an agricultural organization in South Africa, dealt with the question of mineral rights. Mineral rights through legislation was simply expropriated. Now, whenever you expropriate property, and obviously mineral rights also result under property, whenever you expropriate them, money is payable for that as compensation. But there's a provision in the Constitution, Section 25(1), that also defines deprivation. Now, in the case of deprivation of property, when you deprive property instead of expropriating it, no compensation is payable. So, in terms of the definition attached by the Constitutional Court to what has happened in terms of that legislation, there was in fact no expropriation of property, but a deprivation of property, thus exonerating the state from paying any compensation. So that clearly was a pro-transformationist case. What makes it even more interesting is that the court explicitly in that case said that it attached a transformationist interpretation to the legislation. So it once again openly sided themselves with the ideological framework of the governing elite.
Yeah.
Then there was a case of Barnard, which is Barnard was a female person, a white woman, and she was basically disqualified for purposes of promotion in the South African police because what was regarded by the Constitutional Court as more important than the harm that was done to that person, who was clearly, according to that was common, the parties actually agree about that was common cause. Regardless of the fact that she was the best person for promotion, the court said, no, there's actually another value, another consideration that we should attach more value to, and that is the consideration of representativity, representation, namely that the national population profile should be reflected in all levels within the public service, including also the police, as well as a result of which Ms. Barnard was eventually not promoted, as a result of which it was found that the failure to promote her was actually constitutionally in order. And specifically in that case also, the court referred to transformation and gave judgment in favor of the police service, that is, in favor of the state, on the basis of that. Now, there are many other cases that we can refer to, but there's one specific case which, especially in view of the case of the hate speech case, of reform hate speech case against Malema and the so-called economic freedom fighters, a case that we should refer to because it also placed the hate speech case of Malema in proper light. And that is the so-called Glenister 3 case.
Yes.
It dealt with the question whether it was appropriate to replace what was colloquially called the Scorpions, which was a special investigative unit, which with a lot of teeth, so to say, in the sense that they could take very definite action against people involved in large-scale corruption. They were replaced with the Hawks, yes, with much less such teeth. Moreover, the Hawks was also under the police service in terms of the legislation that was adopted in order to replace the Scorpions with the Hawks, under the police, and obviously the police was eventually under the Minister of Law and Order, Safety and Security, that's the correct term, and which is part of cabinet. So what happened is that that whole legislative strategy was questioned and eventually ended up in the Constitutional Court. The essential argument was that the Hawks lacked the necessary independence, also required under certain international instruments South Africa is party to. Why? Because the Hawks fall under the police, and it was argued on behalf of Glenister that the police is actually fundamentally corrupt, and that the police is administered eventually by the Minister of Police and by cabinet, dominated by the African National Congress, and that all of them were essentially deeply corrupt. Now, that's a flagrant allegation to make, conceded. But what happened was, in that case, there was around about 1,000 pages of what was described as expert evidence showing that the allegations were in fact properly substantiated, that it was in fact true that the police was deeply corrupt, deeply also in many cases involved in crime, also in organized crime. In the meantime, since the time that judgment was given in 2015, this has in fact become more serious. So what happened then is that the Constitutional Court, in their wisdom, I should say in their lack of wisdom, decided as follows. They said, no, we cannot allow this evidence because this evidence is scandalous, vexatious, and irrelevant. Now, these are all terms coming from the field of law of evidence. It would be well known to a South African lawyer involved in litigation. It would be as well known to a Canadian or an American or a British or a New Zealander or an Australian lawyer. So in some cases, yes, such evidence can be deleted if they fall under the rubrics of scandalous evidence, irrelevant evidence, and vexatious evidence.
Yes.
Well, the point, and so but the Constitutional Court ruled that out of order. It was dismissed. It wasn't allowed as evidence. The point is, there was a lot of scandals involved in that, but the evidence indicated how scandalous the South African government was under the ANC. So there was no vexatiousness or irrelevance. It was precisely relevant. So what did the Constitutional Court eventually did? I wrote on that. eventually what the Constitutional Court did was the following. In South Africa, we have a political grand narrative, which is a grand history. The history goes as follows. Long, long ago, there was once some paradisical Africa. As a matter of fact, one of the people who said so was none other than the former Chief Justice Mogoeng, basing his assertion on something that eventually proved to be an internet forgery because he referred to some British historian. Okay? But then came the era of colonialism and apartheid. And that was the big fall, the fall into sin. But fortunately, after a long, heroic struggle led by the African National Congress, the big salvation came. And the salvation was when the ANC took over, when the new constitution entered into force in 1994. And since that time, we actually have a splendid dispensation, regulated by the African National Congress under the wonderful leadership of the African National Congress. That's more or less how it went. Everything else, colonialism, apartheid, that was blatantly wrong.
Yes.
But this system is wonderful. Now, what happened is that all that evidence that was given in that case, Keynes said it completely went against that grand narrative and indicated that the grand narrative was in fact wrong, that the African National Congress and the present system is in fact permeated with very serious forms of corruption. So in other words, it disrupted the grand narrative. What the Constitutional Court did, what was, to my mind, a fundamentally ideological judgment in that it protected the grand narrative and together with that the African National Congress. Now what is very interesting is in that case one of the judges was none other than Justice Zondo, who later became the Chief Justice. But before that he was also the chair of the Commission of Inquiry that came to be known as the Zondo Commission. Now in the Zondo Commission, an extreme amount of evidence was given, 100 times more or 1,000 times more evidence that was given in the Glenister 3 case that Mr. Justice Zondo had to listen to, indicating beyond any shadow of doubt that this is in fact what South Africa has become. Now, not much has happened as a result of the Zondo Commission. Why? Because the state institutions that have to act against corruption, crime, and so on are simply so broken down as a result of our dilapidated government, African National Congress, that no proper action was taken. But the value of the Zondo Commission was actually to come to the fore with a proper, reliable definition of what South Africa is.
Yes.
Much more than Glenister case could show. Namely, that it is in fact a deeply corrupt and fundamentally criminal state. And that the ANC, the political leadership is actually part and parcel of that. So that's why that judgment is so important. A judgment that was eventually completely controverted by the findings of the Zondo Commission. Now I actually promised to say something about the case of the hate speech case.
Yes.
But can I proceed?
Yeah, let's talk about that.
Now, the hate speech case, all of us know that, and it's notorious now worldwide. The leader of the economic freedom fighters, and let me just say this because it's important to take note of that, in their public documents, the economic freedom fighters describes Malema, the leader, as also the commander-in-chief. Now, to the best of my knowledge, you find a commander-in-chief only in a military setup. So they regard themselves as military. And that's actually very important as a background to this case, which is part of the evidence in that case. Now, in that case, Malema didn't sing a song. I see the media writes about Malema sang a song. He sang the song, kill the boer, kill the farmer. That's not true. It's a chant. It's a call to arms. Literally speaking, that call to arms is a call to genocide. I know very often the word genocide is too loosely used. But the fact of the matter is that literally speaking, that is nothing but a call for genocide, a call for mass murder. Okay? Unless you can put a spin on it and say, no, this is not what was meant. It actually meant something different. Okay? And what the court then did, on the basis of the argumentation that was tendered by the lawyers on behalf of Malema, was to say, no, this is actually almost something that is innocuous. It doesn't mean anything. There's no intention to harm anybody, in spite of the fact that Malema and his supporters are jumping up and down and making gestures as if they are firing with machine guns and so on, and with pistols. It's nothing. This is the reference to boer, which is the equivalent for Afrikaner, is simply a reference to the erstwhile political dispensation which was mainly run by Afrikaners. So it's a historical thing. It's a commemorative question. It has nothing to do with present day events. In spite of the fact that in that case, Malema was cross-examined by the advocate, by Mark Oppenheimer, and he was specifically asked, Mr. Malema, are you prepared to make a commitment that you would never call for the large-scale killing of white people? And he explicitly said, no, I am not. Indicating through Malema's own evidence that this was not commemorative. This was not some kind of innocuous chant, which is proper political speech. No, this was in fact a call to arms. This was in fact a call to mass murder that sometime, whenever Malema decides, is going to take place. This is what has happened. And this happened, and this was the words of Malema, the commander-in-chief. What did the court do with the evidence? That's a very interesting thing. What did the court do with that evidence? The court ignored it. If you look in the judgment of the High Court, you find no trace of it. If you look at the judgment of the Supreme Court of Appeal, you find no trace of it. So what did the courts do? What did the courts do? And eventually, obviously, the Constitutional Court put a stamp of approval upon that. So what did the courts do? The courts actually decided, we are going to decide this case on the basis of the evidence that we want to take into account. But the relevant evidence, which really goes to the crux of this matter, we're going to ignore that. So that was an abdication of the judicial function. Why? In order to protect something that the EFF, Malema and so on, together with someone together with the African National Congress, including the president, regard as part of their splendid history and something that has to be protected. And what happened was, unfortunately, in spite of proper evidence that was given out of the mouth of Malema himself, the courts refused actually to sanction Malema and to decide that something like that is in fact not only hate speech, it's a call for genocide. So it was a pure political decision. What it eventually boils down to, Ernst, is this. One of the basic things about all courts, apart from their independence, is that there has to be impartiality. Yes. Okay? You have to be impartial also, the courts have to be impartial also when you deal with political cases such as these. Okay? You cannot say, no, impartiality does not go that far. You must also be impartial when it comes to questions of that kind. However, this is simply asked too much of the South African Constitutional Court and also the Supreme Court of Appeal. So it actually shows you my crucial point that the courts are part and parcel of the governing elite in the sense, and they actually justify the views of the governing elite. And to that extent, they are obviously not impartial and obviously indeed an integral element of the governing elite. Yes, you can go to court. Everyday people go to court still on technical questions, on questions regarding motor vehicle accidents, crime, assault, theft, and so on, shoplifting, and many, many other cases, divorce cases, and so on. That's fine. Okay, you could still get good judgments there, and this is still run of the mill, but not when it comes to ideological questions. It stops right there. The integrity of the South African courts, and I know that's harsh words to utter, but they are well founded, and therefore I, as a constitutional jurist, can bluntly say so. They simply lack the impartiality, and they simply lack also the judicial integrity to discharge their functions when it came to questions of that kind.
Yeah. Well, this provides a good segue into the second part of the conversation that we want to have, in which I want to take one step back, and then we can still talk about the courts, but then sort of about the bigger picture of the concerns that we have. So thank you for this, and we're just going to keep the conversation. And if our viewers are watching this, just keep an eye out. You will see that a second part is coming. If you support this initiative and you want to contribute to the work that we are doing, I want to encourage you to click on the link in the description and to sign up as a contributor.